at night. Is that discrimination? No. I hope I'm being clear. Here we have comparison of discrimination theories. We have disparate treatment, disparate impact, and reasonable accommodation. So, disparate treatment, show intent, yes. Individual is a member of a protected group, let's say somebody who's African American, was qualified for the job and was turned down for the job, and the job remained open. Okay, disparate impact, there it says no. Statistical disparity in the effects of facially neutral employment practice. Reasonable accommodation, yes. Individual has a belief or disability provided the employer with notice, request to accommodate, and was adversely affected by failure to accommodation, then you have a problem. The problem with this slide is, I don't like it, it's very, very confusing. So let's talk about employee defense. Produce a legitimate, non-discriminatory reason for the employment decision or show bona fide occupational qualification. In other words, if I could show that I did not hire you because you're black, I did not refuse to hire you because you just didn't have the right qualifications. We actually did this when I worked for the city of New York, in that agency. I had to hire someone. I had to have an EEOC log. In other words, every person I interviewed for that position, I was required to keep fastidious notes. I wrote copious notes explaining why I did not hire that person. What were their positive attributes? What were their negative attributes? Ironically, I hired an African American. She was actually an African. She was from South Africa. She was a woman, and I hired her not because she was a woman, not because she was South African, because she was amazing for the job. And I happened to have enjoyed working with her. I thought she was excellent. But I had to keep that log in case, let's say, the white person or the Chinese person or the other African American person or person from Africa came in and said, I was discriminated against. I would say, really? Okay, let's pull out your file. I didn't hire you because you lacked X, Y, and Z experience. I felt that your technical knowledge of the material was lacking. I felt that you were not a good personality fit. If I say you're not a good personality fit, I don't have to say why. I just don't think so.
You don't have to actually explain to them?
I could say, and if you want me to explain it, I could say it like this. Okay, you want the truth? We have a cool, funky group of people. You're a nerd. You're not going to fit in. You're not the person. I'm not going to use those words, obviously, but I'm going to say your personality would not fit in well with the people here. It would cause friction. I'm not required to hire someone that is toxic to my work environment, even if you're qualified. Remember, and I say this in Principles of Management, you need to have a proper blend, a proper meshing and melding of someone who is fit to do the job physically, mentally, emotionally, and has the requisite knowledge of what they need to do. And in addition to that, they also have to fit in. I don't have to hire a misfit. Someone, and unfortunately many organizations do that. They hire people because they know that they think they can do a great job, but they don't fit in. All right, disparate impact, prove that employment practice bears a manifest relationship with job performance. You have to prove that the employment practice of non-hiring has an issue or its manifest relationship with job performance. And of course, in reasonable accommodation, job relatedness and business necessity, undue hardship or direct threat to health or safety. In other words, if I have to accommodate you, it's going to jeopardize the health and safety of someone else. If I have to accommodate you, it's going to be undue hardship. So again, these are the various issues. All right, I hope that was clear. And the next slide does the same thing. It goes through the plaintiff's rebuttal, monetary damages. I'm not going to go through this. You could read it for yourself. It's quite self-evident. Let's move on. And I highly recommend that you look at the book, because the book, what happens is the table really summarizes what's in the book. I personally don't like this table. I think I would have written it basically, you claim this, what's my claim against that? I wouldn't have this whole yes and no stuff. I just don't like the way it's designed. It's thorny. It's confusing. Okay, let's talk about disparate treatment. When individuals are treated differently because of their race, right? And again, race is your physical features. As I mentioned when we talked about our previous organizational theory and behavior, we're talking about race. So I mentioned racially, it'll be quite difficult to find somebody who's Oriental, who has blonde, curly, red hair and freckles. There's nothing wrong if I did find a Chinese person like that, but it's highly unlikely or probably impossible unless they are, of course, from a mixed marriage. Why? Because racially, people from China have straight, really black hair. Again, they're albinos and people are exceptions, but usually that's not something bad. It's not something good. It is what it is, right? White people are white, and it's black people are black, and it has nothing to do with your color of skin, whether you're good or bad. The color of your skin means that you have more or less pigment. It's a scientific thing.
What, like in some jobs, like modeling or acting, discrimination is like done.
It's rampant. It is rampant, especially when we're talking about people who are heavier or not so heavy. I mean, Abercrombie Fitch, they were sued for not hiring people that were heavy. I mean, there's.
So it's not allowed, like let's say like modeling. I know they.
I mean, look. I mean, you could claim bona fide occupational qualification. You need somebody who's slender. You need somebody who's attractive, right? If you have a modeling agency, again, I don't want to get crass, but you want to model something, you want a woman or a man modeling a product, you're not going to hire somebody who doesn't look impressive to model that product. It's just counterintuitive. But if I'm a modeling agency, or if I used to hire you as a bookkeeper because you got a little bit of couple extra pounds, that's 100% discrimination, because you can't claim, well, we need the image because the bookkeeper has to look, just in case our model calls in sick, I have to call the book. Hey, are you available for a modeling job? That's ridiculous. That would be insane. Nobody would expect that. Again, you could claim bona fide occupational qualification for modeling. You have to be a certain height, certain weight. I mean, listen, there are certain jobs that's part of the territory. Just to flip it around, let's say the job is to be a firefighter. Right, and you're a woman, and you want a job as a firefighter, and there are. I've actually seen in sanitation a female sanitation employee. That means they have to be able to go through the physical activities that are required of them. So, using the fire department as an example, if they have to carry a certain amount of weight up a ladder, or be able to carry a certain amount of equipment, you can't make that less for a woman because that's endangering the woman. Because when you go into a fire, there's no like female rated suit. No, the fire doesn't discriminate against you. If I didn't say, oh, you're a woman, yeah, all right, so you can use this, you don't need that good coat. It's too heavy for you. I won't burn you. It's ridiculous. I'm sending somebody into harm's way. They have to be qualified. Okay? If a woman is qualified to do the job, she gets it. If a woman is not qualified, she doesn't get it. Just like a man who's not qualified for the job shouldn't get the job. Qualified people. The purpose of all these laws is to equal the playing field so that people are not discriminated against. Let's move on over here. So let's look at the bottom here. Disparate treatment exists when individuals in similar situations are treated differently based upon race, color, religion, sex, national origin, age, or disability status. Whenever individuals are treated differently because of their race, sex, or the like, and there is an actual intent to treat them differently, the plaintiff must prove that there was a discriminating motive, that is, the employer intended to discriminate. And bona fide occupational qualification is characteristics that is necessary rather than preferred for a job. So that's pretty much what we have over here. The plaintiff's burden, prima facie, defendant's rebuttal, bona fide occupational qualification. Okay? In other words, I'm not coming in, I'm not discriminating against you. You claim discrimination, I rebut and say no. So let's use my example, plain civil English here without all the Latin lingo over here. Let's say I am telling you I didn't hire you for this position because you're physically unfit to do the job. I may say it's not true, it's not fair, etc., but it's not the case. If I could prove bona fide occupational qualification, then that's that. I want to just do a quick search over here. I got to move this down here. I want to get a good definition for you all, prima facie, based on the first impression accepted as correct until proven otherwise. Okay? That's what it means for all of us that were just looking at that slide. Let's move on. Disparate impact occurs when a neutral employment practice disproportionately excludes a protected group from employment opportunities, or from promotion, that is. Let's say it could be proven, and this Walmart got into trouble for this, for not promoting enough women into management. And again, I'm not going to do the pros and the cons and all that. But if it could be proven that a protected class, such as women, minority women or minorities, were not hired or were not promoted, right? It's disparate impact. Isn't it interesting that this company doesn't hire anybody who's Chinese, anybody who's Jewish, anybody who's Catholic? And this could be a religious thing. It could be as interesting as this. Imagine if a bunch of Catholic people came for a job interview in a Protestant-owned organization, and they were not hired because of their Catholic. And the Catholics and Protestants historically had issues. I don't want to go into the whole history of it. It's not bloody anymore. In the past, it was. But let's say they could say and prove that the reason why this group of Catholics were not hired solely because of religion, and they could prove that, well, then they have a very, very good case. Because they prima facie that we were discriminated against because, upon looking at this case, there was no bona fide occupational qualification, right? Whether I'm Catholic, Jewish, Buddhist, Lubavitch, whatever I am, I could be Hasidish. Do I know the job? And religion has nothing to do with it. It's whether or not you know the job, okay? So again, occurs when a neutral employment practice disproportionately excludes a protected group from employment opportunities. The plaintiff burden, fifth rule, standard deviation rule, and Ward's Cove Packing Company versus Antonio. That's an example of this disparate treatment. Let's look at what the 4/5 and all this other stuff is in the bottom. And this is why it's so important when you're looking at these slides to look at the bottom over here. So disparate impact occurs when a facially neutral employment practice, in other words, looking at it from a first look, prima facie, disproportionately excludes a protected group from employment opportunities. 4/5 rule, a test that has disparate impact if the hiring rate for the minority group is less than 4/5, 80% of the hiring rate of the majority group. Okay? Standard deviation rule uses actual probability distributions to determine adverse impact. So these are mathematical models which will be employed when there is a lawsuit brought. Types of discrimination continued. Disparate impact, what will be the defendant's rebuttal? Must show that the employment practice is a business necessity. So let's say, for example, they could prove that we didn't hire this group because this group, nothing to do with their race or whatever, would affect the business. Now again, I don't know how you'd be able to say that, but I don't know. Let's use the bona fide occupational example. If I hired these older people to do the job, they can get hurt on the job because they don't have the physical capabilities to do the job. We gave them a physical test, they failed. Plaintiff's rebuttal argued that other employment practices could sufficiently meet the employee's goals without adverse impact. All right, that's the answer back. Pattern and practice. Plaintiff attempts to show three things in class action pattern. When there's a class action suit with a bunch of people get together, gang up to sue. Statistical disparities between composition of some group within the company compared to some other relevant group. Individual acts of intentional discrimination that suggest statistical disparity as a function of the larger culture. In other words, that the corporate culture is to discriminate. Promotion and or procedures leave too much discretion to managers, providing the avenue through which unconscious biases can play a part. In other words, you're letting them have too much power. Let's look at the information on the bottom. Number one. So the plaintiff attempts to show three things in showing class action pattern and practice lawsuits. Statistical disparities between composition of some group within the company compared to some other relevant group. In other words, there's only 2% black, or 2% Jewish, or 2% whatever there. Plaintiff tries to show individual acts of intentional discrimination that suggest that the statistical disparity is a function of the larger culture. And plaintiff usually tries to make the case the promotion and or pay procedures leaves too much discretion to managers, causing them to discriminate and, of course, being illegal. Reasonable accommodation places a special obligation on an employer to affirmatively do something to accommodate an individual's disability or religion. Reasonable accommodation is making facilities readily accessible to and usable by individuals with disabilities. And also, let's say I need a room to daven mincha. I need to pray my afternoon prayers. I need 10 minutes to pray. It's a reasonable accommodation to ask my employer to give me 10 minutes a day to pray, or 15 minutes a day to pray. In fact, Ford, I read somewhere, has these non-denominational rooms where you can gather for prayer sessions, whether you're Jewish, Christian or whatever, it doesn't make a difference. They allow you to have a room to pray. And in hospitals, you have chapels, right? If you're Christian, you go to the chapel. They have synagogues. They have a place where if you're Muslim, you could pray, or any other denomination, and that's all a part of that. So again, religion and accommodation. Employee must demonstrate that he or she has a legitimate religious belief and provided the employer with notice of the need to accommodate the religious practice, and that adverse consequences occurred due to the employer failure to accommodate. They were fired, let's say. Disability and accommodation, the plaintiff must show that he or she is qualified applicant with a disability and that the adverse action was taken by a covered entity. In other words, the business purposely didn't hire her or didn't give her reasonable accommodations. Retaliation for participation in opposition. Title VII, employers cannot retaliate against employees for either opposing a perceived illegal employment practice or participating in a proceeding related to an alleged illegal employment practice. And this holds true in sexual harassment as well. If I'm issued a complaint, I blew the whistle, right? Title VII is going to prevent me from getting fired or chastised in any way. Opposition expressing to someone through proper channels that you believe that an illegal employment act has taken place or is taking place, and participation, testifying in an investigation hearing or court proceeding regarding an illegal employment act. So if I'm involved, if I'm one of the witnesses, I can't be fired for that. But the law is not stupid. If somebody says, oh, I was fired because I blew the whistle, they say, no, you were fired because surveillance cameras picked up that you were stealing money from the safe. That's why you're fired. It just so happens to be that you're involved in this legal proceedings. That has nothing to do with that. We have evidence. Hey, let's roll the camera that you stole, or that you yourself did something other act that was illegal. So there's always protection for both sides. We have to be fair and protect everyone. And again, you're welcome to see there's more detail in the bottom of the slide. I want to just move on. Current issues regarding diversity and equal employment opportunities. Sexual harassment refers to unwelcome sexual advances. Charges have been decreasing since 2010. Hostile work environment filings of men have increased. Interesting, men have been it's been increasing. But again, sexual harassment is not just man to woman, although that is the classical example of sexual harassment because that's the way it came about. I speak about this extensively in Principles of Management. Women were introduced to the workforce heavily in World War II and then stayed on. And anytime you put men and women together, there's sexual tension. And that sexual tension causes, can lead to sexual harassment. But it's also the same sex. It can be man to man, woman to woman, female supervisor to male employee, forcing them to engage in all kinds of sexual behavior or favors or things like that. It's all a part of the sexual harassment, hostile work environment. Here you have a sexual harassment charges from 2010 to 2016. Number of charges and percentage filed by men. You can look at it yourself. Slide 28. The definition of sexual harassment: unwelcome sexual advances. Now, again, you're going to ask me. Let's say they welcome it. Let's say a female or a male employee feels good that you mentioned something about their body. Feels good that you wanted to engage with them in some sort of inappropriate behavior after work. That doesn't matter. It's A, it's disgusting, and B, you're going to take a chance. Are you going to be the fool to say, is he or she the type that's going to like this comment? You've got to be out of your mind. It's like taking a grenade and pulling the pin and wondering, what are the chances of it exploding in my hand and killing me? You don't do things like that. It's not, forget about the fact it's unprofessional. That is the least of your problems. That is highly illegal. So again, unwelcome sexual advances, requests for sexual favors, and other verbal or physical contact of a sexual nature constitutes sexual harassment when submission to such conduct is made either explicitly or implicitly, like, hey, if you want to work here, you know what you got to do, and a term or condition of an individual's employment. Submission to or rejection of such conduct by an individual is used as the basis for employment decisions affecting such individual, or such conduct has the purpose or effect of unreasonably interfering with an individual's work performance or creating an intimidating, hostile, and or offensive work environment. So if I make you uncomfortable at work, and as a result, your truancy goes up, you're calling in sick, your performance goes down. There was a story in India that I read about years ago where a woman jumped to her death from the top of an office building because she was being sexually harassed. This holds true for making dirty jokes, lewd gestures, noises, gesticulation of the hands, anything like that, anything that makes somebody feel uncomfortable. Current issues regarding diversity and equal opportunity, affirmative action and reverse discrimination imposes quota programs. You have a famous case of Ritchie versus De Stefano. You could look that up on the internet. I'm not going to go into the whole legal proceedings there. Outcomes of Americans with Disability Acts, the ADA, increased litigation. Many cases being filed are not based on the rights that Congress intended to protect. Again, abuses. People abuse the law all the time. Does not appear to have its anticipated impact on the employment of Americans with disabilities. My personal opinion is the stricter you make the laws, you make it easier for people to abuse the law. In other words, the more you swing it in one person's favor than the other, you're not being fair. You have to be fair. That's the bottom line. People with disabilities have to be treated fairly, and employers need to be treated fairly. It's not, you can't just say, well, employers, you have discriminated for so many years, now we're going to punish you. It's not the way it works. It's not right. LGBT issues. Most businesses are more inclusive. The state of employment law has not caught up yet. The Equality Act of 2017, unlikely to pass. Courts have not made a definitive decision. This is a fluid situation, very, very, very new, and we'll see. We have no idea what will come out yet. Employee safety, the Occupational Safety and Health Act, OSHA, authorizes federal government to establish and enforce occupational safety and health standards for all employees at all places of employment engaging in interstate commerce. Employee rights under OSHA, general duty clause to make sure that we're safe. So what are those clauses? What are those rights? You can request employees have a right to request an inspection of the work site, make sure it's safe. Have a representative present at the inspection. Have dangerous substances identified. Remember, people are exposed to all kinds of chemicals. Perfect example, you're an exterminator. You have a helper, right? As an exterminator, you're required to have material safety data sheet, which shows you the health hazards for each product. You have to know. We had an exterminator come to us, the typical spraying. He left the bill and a material safety data sheet, which explain exactly what the potential harmful effects are. Be promptly informed about exposure to hazards and be given access to accurate records regarding exposure. Have employee violations posted at the work site. It's kind of like when you go to a restaurant and it's got a B rating or a C rating, okay? Continuation of OSHA. OSHA inspections. The compliance officer reviews the employer's records of deaths, injuries, and illness. Remember, somebody gets hurt on the job, you have to report it. The officer, typically accompanied by a representative of the employer and perhaps by a representative of the employees, conducts a walk-around tour of the employee's premises. Employee interviews may take place during the tour. In a closing conference, the compliance officer discusses the findings of the employer, noting any violations. If you really want to see the state that we're in, and how much we've improved, read the book "The Jungle" by Upton Sinclair, and your eyes will open. You'll bug out to see what it was like back in the early 1900s in the Chicago meatpacking industry, how dangerous it was, how food was adulterated, all those things. Read it. See why the FDA had to be created, to save people from all kinds of bad stuff. Almost done here, another couple of slides and we conclude for tonight. The Occupational Safety and Health Act continued citations and penalties. The compliance officer can issue a citation to the employer that specifies the exact practices or situations that violates the act. The employer must post a citation. Fines may be assessed against the employer. Criminal penalties may be assessed depending on the nature of what was found. So the effect of OSHA, raised levels of awareness, does not directly regulate employee behavior. It doesn't. It regulates, again, employee behavior is something that needs to be dealt with, by the supervisor there, by the bosses there. Almost done. Another 2 slides. Safety awareness programs identifying and communicating job hazards, a job hazards analysis technique, and a technique of operations review. If you look at the bottom, we'll talk about that in a second. Reinforcing safe practices, safety incentive programs focuses on specific injuries or disabilities. So safety awareness programs attempt to instill symbolic and substantive changes to a safety program. There are 3 primary components of a safety awareness program: identifying and communicating job hazards so people know what to look out for. The job hazard analysis technique breaks jobs down into basic elements that are then rated for their potential for harm, and technique of operations review, TOR, focuses on past accidents and their causes to kind of think of ways of preventing it from happening again. And table 3.8 talks about a 10-step program for reducing eye-related injuries. If you ever go into an ER, you'll see they have these eye washing stations. We have it in the pharmacy. We're getting all, and I work at a cancer clinic, and we're supposed to get accredited for our pharmacy. So one of the requirements was to have an eye wash station. So somebody gets some sort of chemical in their eyes, they're able to use this solution to wash it out. Conduct an eye hazard job analysis. Test all employees' vision to establish a baseline. Somebody says my vision was impacted. Well, what was your vision before? We have to be able to, before we do this, we have to know exactly what your vision was before. Select protective eyewear designs for specific operations. Establish 100% behavioral compliance program for eyewear. Ensure that eyewear is properly fitted. Okay. Train employees in emergency procedures. Conduct ongoing education programs regarding eye care. Continually review accident prevention strategies. Provide management support. Establish written policies that detailing sanctions, meaning punishments and rewards for specific results. Up to the last slide, promoting safety internationally. Culture differences. Some countries just don't care about safety. I'm going to use an example, Chernobyl, okay? Chernobyl was a perfect example of a government that tried to cover up. The reason Chernobyl was discovered because in Europe they were picking up radiation, and they were tracing the direction based on the winds. It was going back towards Chernobyl, towards Russia. I work in a cancer clinic. I have many, many Russian patients. I have no doubt they're there because of Chernobyl.
I mean,
Chernobyl was a massive cataclysmic event. In my opinion, probably killed millions of people throughout. Will kill millions of people.
What about now? Like, what's the state of it now? Like the radiation.
You can't go there. It's unlivable. People, I actually looked at. It was a History Channel thing on it. People go on tours to Chernobyl, but they're only allowed to be there for like an hour or two, and they have to wear these crazy like lead suits to go in there. They've showed videos of what Chernobyl looks like. It's all abandoned. I mean, it's ridiculous. You see like people's houses, toys, everything was just left over there. It was a tragedy. Everybody that worked on cleaning up the mess over there pretty much died. In America, let me tell you something, America was equally bad. Then when they did all the nuclear testing in the deserts, and you had the Trinity test and Los Alamos, all these other tests, and they had soldiers there being exposed to radiation, they definitely died. They had airmen, they had Air Force people that had to fly over a nuclear weapons explosion through the radiation. I mean, what do you think happened to them? Anyway, that's the whole story. Thank you very much for coming tonight, and have a wonderful evening. That concludes chapter 3.
Yeah.